Hi, everybody, and welcome to today's Germination Retail Roundtable webinar brought to you by 2020 Seed Labs and SeCan. My name is Mark Zinkowitz, and I serve as an editor with Germination, and I'm happy to be your host. Today's theme is intellectual property in 2023, what you need to know. We'll hear from four experts who are going to talk about intellectual property, why it's important, and make sure that you're up on the latest in terms of this important topic. As I say, I'm joined by four guests today. We'll hear from Kim Kenward. She's R&D manager for 2020 Seed Labs. Todd Hyra, Western business manager for SeCan. Anthony Parker, Plant Breeders' Rights Commissioner for the Canadian Food Inspection Agency. And Melanie Reekie, she's IP Services Manager for Seeds Canada. Now, during the presentation, you may have some questions. Please type these into the chat box anytime. This webinar is being recorded and will be available on our website following the event. And again, I would just like to thank our webinar sponsors, 2020 Seed Labs and SeCan. And again, don't be shy. If you have a question, type it into the chat box at any moment. You don't have to wait until we start the Q&A. You can type it in anytime, and please just let us know who it is directed to. Now, first off, we're going to have Anthony Parker speak. Like I say, he is Commissioner for the CFIA's Plant Breeders' Rights Office. There you are, Anthony. How are you today?
Doing very well, Mark. Thanks very much for the invitation to be here today.
Well, thank you for your time, and I'll just let our audience know you may have seen Anthony on the cover of our January issue of Germination. It was great to feature Anthony on that, so he's definitely a well-known face in our community and one of our country's foremost experts on intellectual property matters. He's going to give us a 10,000-foot view of intellectual property, plant breeders' rights, and where things are at right now in terms of Canada's plant breeders' rights framework. So yeah, I'll turn the floor over to you, Anthony, and looking forward to what you have to say.
Yeah, okay, thanks very much, Mark, and good afternoon, everyone. Real pleasure to be here. Thanks for the opportunity. I always like to talk about plant breeders' rights, and I'll give your audience a bit of an update on where things are at and what we sort of have planned for the future. So maybe I'll give you a little refresher on what intellectual property is all about. The slides are a little bit wordy, but don't worry about that. It's really, I'll talk a bit about it, and it's there for a reference for you. Also, you may have heard or maybe forgotten, but quite a few years ago, we upgraded our legislation in 2015 to conform to the most recent international convention on intellectual property for plant varieties. It might be known as, it's known as UPOP 91. You might have heard about it. I'm going to tell you a little bit about what those were. One of the questions I get asked a lot about is, okay, so we changed our law, getting close to a decade now. How are things working? So I'll give you a little bit of insight on that, and then perhaps a few things we have in store for what's next. So intellectual property, very briefly, it refers to things that are the creation of the mind, such as literary works, artistic works, design symbols, inventions, and creation. So we have different forms of IP protection to protect different forms of creation. So you kind of think about copyright in the world of music and literature, so books. You think about patents when you're talking about inventions, you know, things like your iPhone or maybe even vaccines. You think about trademarks, symbols that a company uses for its branding. And of course, plant breeders' rights is a specific form of IP protection for plant varieties. So, you know, why do you have this? Why do you have IP in place? Well, here's kind of the reasoning behind it. Here's the thinking about it, which is we know that society as a whole benefits through progress in research and development. And when those innovations, like new varieties, are commercialized by innovators. So farmers benefit, right? higher yield, higher productivity. Consumers benefit from that. So we want to encourage that, right? So how do you do that? Well, you do that by offering creators or innovators these private rights, and you give them a monopoly over their invention or their creation, so only they can use it. And the thinking is, if we didn't do that, everyone would be a little bit worse off, right? There'd be hesitation to bring those creations or innovations to the marketplace. And the reason why is people could easily steal them, claim ownership, appropriate them, use them for themselves, not fairly compensate. So it's a bit of a trade-off. Innovators come to government and they say, okay, here's my new innovation. I have met all the legal conditions for protection. And then government says, okay, we think society benefits through that innovation, so we're going to give you this IP right, this monopoly over your innovation, but it's not going to be forever. It's going to be time limited. And we hope that you go into the marketplace and disseminate those innovations so everyone benefits from them. And then through your licensing fees or royalties, it helps you recover the costs associated with it, right? So why is this applicable to plant breeders' rights or plant breeding in general? Well, if you know anything about plant breeding, it's really expensive to do. It's time consuming, it's resource intensive. Depending on the crop, in ornamental species, you can develop a new variety in about a year. It's really quick. But something like an apple tree from a cross takes about 20 years. So it can cost thousands of dollars to develop a variety. In the case of varieties that have things like transgenic traits, it can even be in the millions of dollars for a variety. And whoever invests, it could be public sector or private sector or partnership or non-for-profit or small or medium or large, those costs are all invested up front before a variety comes to the marketplace. So the way that we describe it is we say the fixed costs, all those upfront development costs are really high, but the reproduction costs are really low, right? Plants make copies of themselves, right? That's what they do, and that's very useful. But someone else can appropriate another person's work or innovation, reap all the economic benefits from them, and provide very little back in terms of fair compensation or remuneration. So plants can easily be stolen or reproduced or sold without permission or fair compensation. So if this system works well and your IP is successful for you, you can license and collect royalties. And this benefits both public breeding, private breeding, or partnerships between the two. So I described before, Canada, recently amended its legislation in 2015 to comply to UPOP 91. That's the most current international convention. Prior to that, we were at a weaker form of IP rights called UPOP 78. And in both cases, what we wanted to accomplish by having this plant breeders' rights framework in place is to stimulate investment in plant breeding in Canada, both public and private, to provide Canadian farmers with better access to foreign varieties, and also support our own breeders when they go out to protect their Canadian bred varieties internationally. And we really accomplished all those goals, but there's always room for improvement. So a few things that you should know about plant breeders' rights is the moment that a plant breeder files for protection, they do benefit from something called provisional protection. So while that period between filing an application and pending their grant of rights, while it's being examined, the applicant or the breeder benefits from all the rights they would have had if they bring it to protection. So that's really important. Just because something has been filed doesn't mean so anyone can do anything they want with it. Those rights are enforced from the day that an application has been filed. That's really important to know. The breeder has exclusive rights over all activities associated with bringing a variety to marketplace. That can be sale, production of the variety, reproduction of the variety. So, making more of it, bulking up, multiplying it, conditioning and treating, importing or exporting the propagating material, and stocking. That is all the exclusive rights of the breeder. There's a provision in our law that's really, really important, and it's there to deter brown bag sales of seed. And that is if a breeder didn't have the opportunity to exercise the rights on the propagating material, so the seed of a variety, if someone now takes that and sells it to a neighbor, sells it to someone else as their own, reaping economic benefits, it flips over to the harvested material. So the breeder can exercise their rights over grain. So it's not only just the seller of brown bag sales of seed, but also the buyer and anyone else that they can sell to have now been implicated, and the breeder can exercise the rights. So this is potentially really damaging. Don't do it. Don't engage in sales of brown bag seed. So there is one new provision too, is that a breeder can test the market up to 1 year in Canada, try out a variety, see how it works, and still be eligible to file for PBR protection. And the rights are enforced for 20 years. So that may sound like a long period of time, but what we see in the marketplace is there's a lot of turnover. Newer varieties displace older varieties. And once it becomes an older variety, often the title holder will surrender their rights early. They say, okay, the market share has gone down for this. I no longer need intellectual property protection. So here's a good example. In wheat, we've done some analysis, and there's some really great wheat varieties that last on the marketplace for a long period of time. There's some that really disappear quickly within a year or two. You know, the average tends to be about 5 years, that 5 to 6 years that a title holder will hold rights. So AFC will probably hold it for 5 or 6 years, unless it's really a stellar variety. And then they release it and it becomes public domain. It's free without restriction. So there are really important elements in the law to balance interests, balance it between different breeders and balance it between breeders and farmers. There's something called the breeder's exemption. So a breeder can use another breeder's PBR protected variety and integrate that into their breeding program, make crosses with it, and they don't have to seek authorization. So that's really important to keep things open-ended and competitive. So here's an example. You know, a lot of AFC successful CWRS varieties have in their pedigree, well, North Dakota State University lines, Syngenta lines, maybe even Crop Development Center lines that they've used and crossed with to create new varieties. The research exemption ensures that anyone can use a PBR protected variety and publish about it. So you can do trials about the attributes of it. It could be in your co-op trials, and you can say, okay, this variety has great yield, this one does not so much. So anyone can do that without asking permission. There's something called a private non-commercial use exemption. It's really about hobbyists. So if you're in a non-commercial activity and you're kind of using it in your backyard, you can have a variety and not seek authorization, do all sorts of things with it. And there's also a really important provision called the farmer's privilege you might have heard of. It's the ability to save and reuse seed of a farmer on their own holdings of a PBR protected variety, and they can do so without restriction. However, they can't sell to others. That would be brown bagging. And in an ideal world, it would be with some fair compensation, equitable remuneration back to the breeder. So the idea is, I benefited economically from your innovation, and therefore I should share some of that back. Of course, in Canada, we have the authority in the Act to do so, and we went out a few years ago and did something called value creation consultations. We were invited by the seed sector and producer commissions to go out and talk about this. And really, there was no consensus. We asked the question, do you think an endpoint royalty would be good, or a farm safe seed? We had divided viewpoints. Should it be a fixed rate or a variable rate? Divided viewpoints of it. Some thought we should not pay anything whatsoever, right? So we have kind of left it at that point in time and have indicated, you know, producer community and seed industry, when you're ready to talk about this again, will always be available. But that at this point in time, it's sort of left somewhat unfinished. But nevertheless, so enforcement, what you really need to know about this is government plays no direct role in enforcement. If you're a title holder, if you're Agriculture and Agri-Food Canada or you're Syngenta or Corteva, it is your rights and it is up to you to enforce that in the marketplace. Some title holders like AFC, and we have Todd Hyra from SeCan, as part of the licensing agreement, might pass that responsibility on to SeCan to do. So SeCan, you do the enforcement on our behalf. Some things that you should be aware of is that we call them remedies. The way that you address infringement of PBR is through the court system. If it's in regional in nature, you might decide to go to the provincial court. If it's across the country, you might decide that your starting point is the federal court. And there's really two fundamental principles in IP enforcement. First is stop the infringing activity from occurring. Sometimes it's just that people aren't aware that this is an infringement. Could be as simple as a conversation. It could be a cease and desist letter, which is to say, look, stop this activity from occurring. Some infringers continue to do that, so you might need something called an injunction or a court order to stop that. And the second part of the equation is, now it's time to settle up what the damages were. So most cases in plant breeders' rights, in fact, every case that we've had in 30 years in plant breeders' rights, there's been a settlement outside of court. If it were to go to court, a judge would have to rule on compensatory damages. So how much harm was caused by the infringing activity. Possibly the judge could have the discretion to decide on accounting of profits instead, and possibly put in place punitive damages. So punitive damages is something that if an infringer continues to be uncooperative, a judge might decide to say, well, we need to make an example here and put a price tag on someone who has been uncooperative through this settlement process. The message, of course, to seed companies and retailers, those who hold title of plant breeders' rights, your right is only as effective as your willingness to enforce. No one wants to enforce the right, but when you have infringement, you have to do it. It's part of your obligation, especially if you want your IP rights to be very successful. So a couple of questions I get asked about, and I'll talk a little bit. Okay, you changed the law in 2015, you upgraded, how are things going? In general, we'd have to say things are working fairly well. They're much better than they did, and I think this graph kind of illustrates it. When we were on this older form of intellectual property protection, UPOV 78, we were starting to lose IP rights pretty quickly, 5 to 10% per year. 2015, we made the change, and we were starting to regain new filings. So we became a much more attractive place for investment than we were. So I think that's good news. We've done some economic analysis comparing how were we doing in the years up to the change in the law from 2009 to 2014, and then the 5 years afterwards. And generally, we're seeing positive signs in the marketplace. So we took various crop species that hold plant breeders' rights, examined before and after, and here's a chart. This is going to be in some economic analysis that we're going to release later on this spring to say, okay, how are things working? Did it have an impact? And I would caution, I wouldn't read too much into this. Economic growth was going to happen. The most we can say is at least the changes certainly didn't do any harm, and we think that we've had some additive value. So in general, production's gone up, yields have gone up, farm cash receipts have gone up, export value has gone up, export volumes have gone up. So there was a move in the right direction. We also asked some of our clientele kind of what did they think. So the users, PBR, plant breeders, agents, title holders, we asked them last winter in a survey process that will also be published as part of an economic study later on this spring. Do you think that strengthened PBR protection has encouraged more investment in plant breeding? Most agree. Some are uncertain. They're not sure. And I think a lot of the feedback we received was asking that question 5 years after is perhaps a little bit too soon. Generally, we start to see the impact kind of in that 7 to 10 year range afterwards. So, but generally, the viewpoint is we're on the right direction. We also asked a question of special interest groups, so producer commissions, general farm organizations, the seed trade, the ornamental sector, the fruit and veg sector, both internationally and domestically, has upgrading Canada's PBR Act, improved our international competitiveness. We've even asked some special interest groups who really are strongly opposed to intellectual property and plant breeders' rights. What did they think? We want to know what they think as well too. And overwhelming majority seems to think that has improved our situation in terms of international competitiveness, drawing more investment into plant breeding. So some new things that you should be aware of. In June 2022, the Minister of Agriculture appointed her new Plant Breeders' Rights Advisory Committee. This is a really important body. The law says, the Plant Breeders' Rights Act says that the minister shall appoint a committee that is made up of balanced representation of the sector to help me with the administration of the act. So it has to have farmers, it has to have seed growers, it has to have seed industry, it has to have breeders, both public and private, it has to have the ornamental sector, it has to have the fruit and veg sector. So some of you may know our former chair of the advisory committee, Kofi Agblor. He's here on the slide. In 2022, in December, the advisory committee appointed a new chair for a 3-year term, and that's Miss Deb Hart. She was with the Canadian Potato Council, and she will be serving as chair of the Plant Breeders' Rights Advisory Committee for the next 3 years. And Mark and Ashley of Germination Magazine were kind enough to do a piece on this advisory committee in the most recent publication. So if you want to know who represents different interests on this advisory committee, for many of you, probably some of these names won't be any strangers to you. Keith Degenhart from Western Grains Research Foundation sits on it. Rob Graff, retired winter wheat breeder, who's agreed to stay on from Agriculture and Agri-Food Canada. Dr. Anna Badea from Agriculture and Agri-Food Canada, barley breeder. We also have the seed industry represented by Lauren Cummin, and also from Corteva, Allison Coleman. And we have seed growers on the committee. So Miss Lori Otway, who runs a seed farm with her husband Ward in Alberta, but also works at Olds College, and Steve Tomtine from Tomtine Seed Farm. So we're going to have discussions with this committee over the next couple of years, talking about what further improvements can we make to the PBR framework in Canada to attract more investment, more innovation, and make our breeding programs, both public and private, more sustainable. So thanks very much.
Thank you very much, Anthony. That was terrific. And actually, I'd like to, before we start Todd and Melanie's presentation, normally I save questions until the end, Anthony, but there's a couple of really timely ones here I think I'd just like to tackle quickly before we start Todd and Melanie's presentation, if I could.
Sure.
I'm thinking you're probably best to direct these two because they're quite technical. Would applying PBR for a hybrid cultivar automatically transfer the PBR to all the parental lines? What are the implications in such a case, especially if the restorer is an already released variety? Do you have any insights there?
Excellent question. Really great question. So one I didn't touch on my presentation. What we generally see with breeders of hybrid crops is they protect the inbred parent. And what it says in our law is something to the effect of to say, when you protect a variety, an inbred parental line is a variety, it's distinct, uniform, and stable. And that variety is always needed to create another variety, the hybrid progeny, the F1. Whenever that protected parental line is used in a hybrid, the PBR protection extends to that hybrid. So certainly we often see companies, especially in canola or corn, protect at least one of the parental inbred lines, but they will often protect both of them. in a two-way cross. So our advice is always, if you want to get the maximum protection, protect the inbred parent, and that protection of the inbred parent extends to any line or any variety for which you use it in a hybrid.
One more question. Do you anticipate an increase in infringement court cases with strengthened rights under UPOV 91?
Yeah, that's a great question. I do. I think so. I think enforcement or infringement court cases is probably not the best way to go overall. What you hope to do is avoid infringement altogether, and that is really about education. It's kind of shifting a culture to understand that it's the right thing to do not to infringe. And that might sound a little bit silly, but when you infringe, you might be acting in your own self-interest. You might be profiteering for something. But if you can change the culture and the discussion out there to say, you know, if we're known for infringement, if we have high levels of infringement, you know, that's going to undermine us collectively on a long-term basis to attract investment and innovation. So how do we switch that to understand it's no different than copyright with an author or a musician or a patentee with an invention, which is to say, if I adhere to the IP rights, if I pay my fair share, if I don't infringe, we will become a very attractive marketplace for investment, innovation, and plant breeding, both public and private, or partnership, or small or medium and large, and that's to benefit for everyone. So I think, you know, we do anticipate with stronger rights, yeah, we'll probably get more enforcement, more court cases. My own view on it, the right way to go is things like this, raising awareness of the importance of IP and how IP ties into our long-term success in the agricultural sector. And that's, don't do it because it's the wrong thing to do, not that you're going to get punished for it. So.
Exactly. Well, and that's what we're going to do next is educate and test people's knowledge of IP. So thank you so much for that great presentation, Anthony. Hang on the line in case we have a few more questions.
My pleasure.
Now, thank you. And I'd like to introduce Todd Hyra of SeCan, Western Business Manager for SeCan, and Melanie Reekie, IP Manager for Seeds Canada. Hi, guys. How are you today?
Doing great, Mark. Good to be here.
Yeah, well, I'm glad to have you because we're going to do something a little bit different that we've never really done before, and we're going to have sometimes we send out poll questions to the audience. I sent one out earlier, but we're going to have an interactive quiz now, which is a little bit different and something that people can get really interactive with using their phone. So not to jump the gun here, Todd, but I'll just let everyone know that if they want to get their phones out, that you're going to put a QR code up here for them to scan. That'll take them into the quiz, but you're going to explain all that. So I'll turn the floor over to you guys. Looking forward to this.
Absolutely. So thank you very much, Mark. And sorry to stress you out with trying something new near the end of the webinar series. But we thought it'd be a great way to benchmark some of the information that Anthony presented, but also have a fun, interactive way of gathering some feedback on the process. And so this is about it, awareness and enforcement. And the tagline I've chosen is a shared responsibility, because it's really about all of us to share this with one another, our customers, whether you're a retailer, a plant breeder, or a farmer, is to share this information so that we have greater awareness and we can not rely as heavily on the enforcement component if not needed. That's the least amount of fun. So as Mark mentioned, there's a QR code on the screen. And so if you want to dig out your phone, you can anonymously reply to the survey questions. And there's nothing really too stressful here. And if you lose it at some point in time, or your phone loses the connection, you go to menti.com and the code is at the top of the screen, and that's at the top of every slide. So if everybody wants to hit that thumbs up in the bottom and just let me know that we've got a reasonable number, we'll jump into the presentation right now. I think we've got 6, 7, 9. Oh, there we go. Okay, we're getting there. So yeah, once again, scan that QR code, use your phone, or go to menti.com and enter 3869956, which is at the top of the screen.
Yeah, if you have your phone, if you go into the camera app and scan it with the camera app, it should automatically scan the code. It'll give you a URL, and then you just hit the thumbs up, and then that'll log you into the system.
Yeah, my kids mock me for not being with it. So I assume if I can do it, anybody can do it. So anyway, we're at 24, so we're going to jump in now. Easy one off the start. Just type in where you live. You can use the country or the city or the province just to type in where you live, and we'll see where everybody is. Excellent. Lots from Canada, but some international participation as well. So welcome.
Neat.
Excellent. See, I told you it was going to be fun, Mark.
So after we've answered, Todd, do we hit next question?
No, I just go. So okay. I'm in control here. So I'll just move forward. I just wanted to make sure we were we had around 31 participants. So I wanted to make sure everybody was in. We'll keep it moving quickly now. So what is your role in the seed industry? Just so we know who we're speaking to, seed retailer, distributor, farmer, seed grower, or other. Just to get a handle on who's listening in on the webinar. And don't worry if I bounce the slide forward and you haven't had a chance to reply, you can still go back and reply. So lots of other. I guess I should have thought of some other categories. That a lot of distributors and on the line. All right. So these are slide questions, so you can slide the bars to the right if you strongly agree with the questions. So plant breeding is critical to my business. Plant breeders need a return on investment, or PBR is important to our industry. And so you can just slide those indicators across and let us know what you think about those three statements.
This is a great way to get feedback. Wow.
Yeah, it's fun to have the interactive opportunity as well. So we're up over 26 now, and kind of got the numbers stabilized. So yeah, as everybody can see, PBR and plant breeding is pretty important to our industry. This is a slide for those that followed me a few years ago, and we were talking about value creation. And Anthony talked about the time to bring a variety to market. And so I think of it as this funnel where you're literally pulling in tens of thousands, if not 1 million lines at the start of the process. We have 1 million different plants, and then throwing away a large portion. This is a very simplified version, but you're throwing away 90% of what you do each year to try and find that one good product. And so this is a mock-up that I've used from a sort of a larger wheat breeding program from a few years ago. And at the end of that process, once you've been through a registration process in Canada, you hope to have that one successful variety. So you're looking at 10 to 12, maybe 13 years if you go the full route. There are shortcuts that you can take, but once again, it's it's a very time-consuming, expensive process to take a variety from initial cross in cereal crops to release. And plant breeding is funded in different ways. And so this is a university breeding program example where there is some university funds that are put in. There may be some corporate funds and sponsorship that goes into a breeding program. Typically in Canada, we have some producer participation as well, so that there's producer checkoff dollars that would flow in. Then there's a royalty component, and then sometimes the province will or the federal government will kick in some additional money as well for some of these programs. And each one varies. And so the important message that I wanted to get across here is that there's different components that make up how a breeder is paid or how a breeding program is funded. And the one piece, that royalty piece, is an important piece that needs to grow to keep our programs competitive. This is an interesting slide, and it's kind of a snapshot of a 15-year average of certified seed use in Western Canada. And so this would essentially say that in Western Canada, spring wheat breeders are capturing royalty on about a quarter of the acres that are across Western Canada. Barley's 28%, oats is around 25%, and durum is only at 11%. And so there's a lot of upside potential to draw additional funding in to support those programs. And once again, this is a very Western Canada specific example. So now's we're going to dive back into interactive, and we're going to turn things over to Melanie, and she's going to take you through some questions specific to PBR.
Okay, hello everyone. I'm Mel Reekie. I'm the Intellectual Property Services Manager with Seeds Canada. I would like to refer to myself more as an expert in training. I started with Seeds Canada, I don't know, just over a year ago now. I've been kind of taking over, I'm sure many of you are aware of Lauren Hadley. I've been kind of taking over the operational side of things, marketplace monitoring, etc. on that front with Seeds Canada. So basically, knowledge is power for everybody. Anthony and Todd, Mark, everybody has mentioned it already, but this is kind of part of our education piece towards industry. We're here to support you guys as retailers, as your others, and however you identify in the industry. We are here to help. We're here to support you with whatever you guys need. So basically, through the next number of slides that we have, it is a bit of a tester knowledge, and we kind of look at it as kind of highlights of what you need to be aware of on the PBR front. So I guess we can dive in at any time now. So the first one, who is responsible for PBR education? The variety owner, the retailer, customer, industry, government, or all of the above. I can't see who, is that one finished, Todd?
Yeah, this one I kind of jumped the gun. There's a timer set on some of the,
okay.
on that one, and so it actually
okay, perfect.
Yeah.
I am not always short on words either, so we'll see how that goes. I'll be more attentive on that front. So,
well, I like how the faster you answer, the more points you get. So that's kind of cool.
Oh, okay. So basically, we're all responsible for PBR education. There's experts along the field throughout the value chain that you can lean on if you have questions, etc. You can always refer to our website. But I think it's very important to acknowledge that I don't think any of us can be excluded from educating on PBR. It's something that we all need to be aware of and work together on that front. So yeah, I think we can go on to the next one, and I'll be cognizant of time. So when plant breeders' rights are granted, the breeder gets exclusive rights in relation to propagating material of the new plant variety. So that's basic true or false. I'm not sure how many, it looks like 14 at the bottom, but 15.
We're up over 20 now. And we'll have Anthony jump in if we need an official ruling.
Right. I'll go on the in training. Hopefully all my answers are right. It is true. So once the rights are granted, the breeder does get exclusive rights in relation to propagating. So that is something to be cognizant of. Brown bagging is not acceptable in any way, shape, or form. So yeah, I think we can move on. That's pretty standard unless anybody has any questions for Anthony or any of us on that front. Since 1990, Canada has had legislation called Plant Breeders' Rights Act. This law is administered by CFIA's Plant Breeders' Rights Office. Everybody's looking good on that front. Everyone's paying attention. I should have allocated some swag to throw out to somebody at some point, but we can still maybe do that. Okay, so that was true. So as of February 27th, 2015, all new varieties submitted for PBR protection in Canada are protected under the newer legislation that conforms to the UPOV 91 Convention. So that brought us back in line with the rest of the world. As Anthony touched on too, it opened opportunities for increased investment. And basically, ultimately, that is going to lead to more varieties that are available to Canadian farmers. So it's a good thing all around. So I think moving on to the next one, So if you don't know, I suspect most people know, but I mean, you can never assume things. The PBR 91 symbol. With regards to the PBR today, most of what we're talking about is the 91. That's the space that we live in these days. So if anybody ever has any farmers not sure what that means, there is a specific logo that can be found with related varieties, and that's what you see on your screen. In my marketplace monitoring, I often refer to CFIA's. They have a listing by crop kind and then breaks down by variety. The status of plant breeders' rights, whether they've been applied for and when the rights terminate. That's quite helpful. So you can always refer to that if you're not sure. You can always look it up. So if you want to flip to the next slide, I think, Todd. This is just kind of handy. I pulled it up. This is what you see. The application date, it shows the application date, the first kind of yellow mark there. And then at the bottom, that's kind of what I refer to in my marketplace monitoring on most things. It shows the termination date on the rights. So Anthony touched on that. I mean, we're well aware that some varieties are more successful once they're put into production than others, or various reasons on why varieties are in and out of the marketplace at different timelines in their lives. But one thing that I have found through the monitoring process is that some guys assume that because it's maybe not the headliner variety at this time, then it no longer conforms to any rules or what have you. They just kind of assume you can do whatever. I have had that conversation with a few people. So it is important to note that the termination date, it is quite lengthy. It just doesn't terminate overnight. So I wanted to kind of point that out because that is one thing that I have found that I've ran into just in discussions with people. So yeah, you can always refer to CFIA. You can refer to our website as well. We have a database that kind of mimics what CFIA has. So there's limitless potential with Google nowadays on finding the information you need. I think we can go on to the next one, Todd. I think we're back to a question. So conforming to UPOV 91 has not only brought opportunity, but it has also brought new obligations for the value chain. So as far as what those obligations would be, I have a really hard time reading those right now, but farmer's privilege is entrenched. Seed conditioners also have responsibilities, as well as grain buyers. So make your choice, and we'll wait a couple of seconds. We've got a few people there now.
So it is all the above.
Okay, yes. Sorry, that finished off there, Todd?
I clicked the, we were heading in the right direction, so I gave it the.
Okay. So yes, I'm just going to read off this screen because I can actually read it. But there are some significant changes as far as responsibilities down the value chain with UPOV 91. So farmer's privilege is now entrenched in legislation. Seed conditioners, you do have certain responsibilities, as you may be liable for any of the breaches of the breeder's right. And then also grain buyers, they do have certain responsibilities and may be liable. So as a grain buyer, you kind of just need to be satisfied that the seed used to produce the grain that you're receiving has been purchased legally. So yeah, that kind of wraps that one up. If we move on to the next. So yes or no, is Canada's Plant Breeders' Rights Program voluntary? So a breeder may choose to protect a variety or not.
Looks like everybody's on the right track there, so the answer is yes.
I think we're good. Yes, so it is a voluntary program. So again, you can always refer to the websites on whether the variety you're looking at is covered or not. It's a good thing to be in the know. Most, as far as cereals, probably, Todd, correct me if I'm wrong here, but I mean, the vast majority of them are PBR 91, you can assume. Yes?
Yeah, there's the odd exception where a variety may be too old to apply. And in
Right.
those particular cases, if they've timed out because they were released in another part of the world earlier, then there's the odd exception. But by and large, if it's a strong agronomic type that is going to reward the breeding program, they're absolutely going to protect it.
Okay. So the next one, so plant breeders' rights do not restrict anyone from using the protected variety 4. So these are a couple exceptions, I guess you could say. So private and non-commercial purposes, experimental purposes, breeding and developing new plant varieties, and then storing and saving seed harvested from a protected variety for planting by farmers on their own land. So that's your farmer's privilege. You are allowed to seed from the grain produced, but you are limited to your own operation. No selling, no trading, no handshaking. It's your own land. So just building on that one, farmer's privilege, can farmers save seed? Oh, did I put everybody to sleep? We only have, oh, there we go. It's like,
This is more of a thinker. There's a lot to read there.
Sometimes it takes a moment.
okay.
I'll show the answers. There we go.
Okay, so on that one, basically,
Really, they're all right.
What's that? Yeah, they kind of are all right. On where PBR 91, it is spelled out clearly in legislation, and although it wasn't necessary as black and white on PBR, it's not prohibited. So both A and B, but A and B work too.
A and B, yeah, it's the stronger, the most right.
Yeah. So once granted, if it's not surrendered by the breeder, how long do plant breeders' rights last for field crops specifically? Oh, someone's paying attention. It's quick.
You're listening to Anthony. That's awesome. Yeah, the correct answer is 17 for field, or sorry, is 20 for field crops. But I think they're for trees and woody plants would be 25, right?
Yeah. Okay, so I think we're getting near the end here. So this is just a general. Seeds Canada does monitor the marketplace on behalf of industry, reviewing online advertisements for non-pedigreed seed. And that's a simple 50-50, true or false.
So that is correct. Absolutely true.
Yes. So I am the person behind the marketplace monitoring at Seeds Canada. I will say, though, I think it's a good opportunity to say, as far as, everybody working together in this space, although with Seeds Canada, we dedicate time, energy, resource to specific monitoring, it is kind of a collective effort. As retailers, as seed growers, as whoever you are in the industry, you can always touch base. I think in a couple slides we have my direct contact for that. But it is important to note, we do the monitoring, but we don't see the poster that's, stuck to the door at PV Mart or, however you see it like that. So feel free to pass those along to us. We do have our finger on the pulse on things, but we're always open if you send us information, if you see something on Twitter or what have you. So we'll go into that, I think, in the next slide, maybe, if I'm not mistaken. Oh, here we go. You're on this one, Todd.
Yeah, so I've got some statements on here. Once again, these are the slides. So unless I am authorized, you can slide to the right if you strongly agree with each of these statements. It's illegal for me to sell a protected variety. It's illegal for me to process a protected variety that will be resold. Trading seed or giving seed is considered a sale. It's illegal for me to grow a protected variety I did not purchase legally. Grain handler in possession of grain grown with seed not legally purchased can be held liable. And so we've got a few in there now, so let's keep those coming.
Good questions, guys. You made it quite challenging, actually. You have to think about these.
Half in there now, and most are strongly agreeing with all those statements, so that is very positive, because each of those is indeed true. And as Melanie had indicated, and as we talked off the start, it's a shared responsibility. And so one of the most awkward parts of my job is the intellectual property protection and enforcement. And so I'd much rather have the industry talking about this, sharing information, and not having to go that enforcement step, because that's where things get expensive, and it's far better to just not have the illegal sales happen in the first place. They're taking directly out of the hands of our plant breeding programs that are working to benefit all of us. We'll move on to the next one.
So this is just kind of highlighting again that as seed retailers and all of us, we do play a critical role in the effort to inform and educate. So once again, if you do encounter an advertisement for a non-pedigreed seed, which you feel that may be a potential IP infringement, that could be on your social channel network or a hard copy advertisement at PV Mart, Co-op, what have you, you can send details to myself. Or, one of your reps at SeCan, use your channels, use your network, and we can ultimately follow up. And I mean, do we approach that with, hey, Bob sent me a note that you might be doing something illegal? We don't do it like that. We keep it anonymous on that front as far as, just inquiring. We have a bit of a process that we go through as far as, reaching out with a monitoring style note, inquiring on the specific variety, or if the variety is known, we kind of take a different path. So yeah, feel free. We don't share your name that you have, brought it to our attention. We don't take an approach like that. So it is a safe place to send us any comments. If you need anything, you can get my email here or also on the Seeds Canada website. I'm available just on a click. As far as emails go, I think does that wrap us up, Todd?
It does.
It does. Do you have anything else? Oh, before I forget, actually, speaking of social channels, I believe just this week, I should have plunked it in there. That's my bad. We will be highlighting PBR compliance on our Twitter and LinkedIn and I believe Facebook pages. So if you follow us on seeds_Canada on Twitter, you'll see a couple graphics and just some information piece as far as PBR compliance. And feel free to retweet, tweet, etc. in your social networks.
Excellent. Please do that, everyone. If you are on social media, please make sure and help out with that effort, because it's important. So thank you, Todd and Melanie, for that great presentation. That was a lot of fun. Now, before we do one last Q&A at the end here, we're just going to hear from Kim Kenward. She's R&D manager for 2020 Seed Labs. I recorded a short 5-minute chat with her the other day in regards to proficiency testing and how Seed Labs can help protect intellectual property and get the word out. A lot of retailers work with seed labs on a regular basis, and so this is something important that we wanted to fit in there with regards to proficiency testing. So again, we just have a short 5-minute chat with Kim, and then we'll take a few questions at the very end before we sign off for the day. Kim, good to see you again. Thank you for joining us on the webinar. How are you?
I'm very good. Thank you, Mark. It's nice seeing you again.
Yeah, you too. Now, we're going to talk about seed labs and IP and something called proficiency testing and why it's important and how retailers can be impacted. But first of all, I'd like to give people a general idea of what kind of intellectual property seed labs deal with on a regular basis. Can you enlighten us there a little bit?
Well, we deal with intellectual property on a couple different levels. The simplest one is where it's actually held by other people, and this would be a very good example in terms of a chunk of our GM testing. So the IP holder in that case has actually developed their own protocol, and they have a designated marker that they would like us to use to do the identification. So what happens there is that they send us the protocol and we validate it and work it up in-house to make sure it's working. And then we do a proficiency test to it so that we have oversight from the IP holder to run their protocol to their satisfaction that the results are ones that they can actually trust. And then they will then authorize us to run that protocol on their behalf. And a lot of this is used by, say, the breeders or for variety registration purposes. The other side of intellectual property is the stuff that we develop in-house. So that's where we get actively involved in finding the markers and deciding how they're going to be used, and then develop the method ourselves. So sometimes that's done in association with a person of interest. So the best example of that would be like wheat midge, where you have a breeder that has a specific trait that they want to protect. They need a refuge content in there, but they don't actually know how to actually do the testing to make sure that the refuge is at the correct amount. So we'll go in, we'll select a marker, and we'll work out a method and a protocol to do it. And then they will go in and they'll do a blind test oversight on it to make sure that they agree with our results. But in this case, the intellectual property is held by us because it's our choice of markers and our protocol that we're running. And then if you go further down the line, there are the protocols that we develop for ourselves and that we then offer, but then that goes through our own proficiency standards within the lab.
And so how are retailers, people who sell seed, impacted by this? In other words, why should they be aware of it?
It affects the confidence with which you can actually use the results. In some cases, like for the proprietary license holder, where you have like GM traits and you have a breeder, you'll run into situations where you are required to use a particular protocol by the IP holder. So you want to know who is authorized to run that and to a standard that will be accepted by the original IP owner, and so that they will trust those results. You also have another layer of regulation where someone like CFIA will only accept specific protocols to be run by authorized people so that they can actually register the variety as containing this particular element present within it. On the other side of things like wheat midge, when we go through our proficiency testing and innovation, what ends up happening there is that the breeder or their designated body, such as a distributor, will authorize CSGA to accept results from a lab that they've put through proficiency. So you can only actually get approval to sell that seed from CSGA, who had been authorized by the breeder or the IP holder to actually accept those results.
And so what is the value of proficiency testing then for retailers?
Proficiency provides confidence in end results. Okay, there are probably a lot fewer standards out there than people think, and so, but proficiency is there to fill the gap. Okay, it allows for innovation, so an independent body can come in and create a test. They don't have to divulge any of their tests so that their competitors can then come in and actually start offering the test. But it tests for fitness of purpose to make sure it's doing the job that it's meant to do, and you can actually believe the results.
And so people who sell seed, retailers, what do they need to ask their seed lab in regards to this?
Depending on what level of protocol you're asking for, there's very specific needs that you should be looking for. So if it's something that's a licensed protocol that's coming from an IP holder, you need to know that they've actually been approved by the IP holder. So for GM, we have some tests that specifically state that this is done according to the proficiency as authorized by these specific companies. In terms of wheat midge, we have like we are listed with CSGA as being allowed to provide those tests, and the distributors are actually telling their people who to go to in terms of labs that can actually run the tests for this refuge concentration. In situations where you don't have a third party actually authorizing proficiency, then you need to look at individual lab standards. So a good way of looking at that is to see if what their certification is and what other proficiencies they're already running in the lab. So that can be coming from places like the IP holder, or it can be coming from places like ISTA or ISO, and that are regularly running those, in addition to any internal testing that they've been doing on their own within the lab. So when we actually develop some of our tests that are unique to us, we often did blind tests, either with our QMS manager, or we actually went back to the person that published the test, and we sort of said, look, we've developed this test. We think it's working really well. Could you set up a blind test for us that we could then actually run our test on and see if it works to your satisfaction as being like a person that published in this area?
Okay. So it's important then for retailers to be aware of not just proficiency testing, but some of the intricacies around that, and work with their seed lab to make sure that they're getting the best information possible.
That's what I would recommend.
Sounds good. Thank you so much for your time today.
It's been a pleasure. Thank you.
Great. Thank you so much to Kim for that. That was super helpful, technical, but important for people to know. And so I'm just going to check our Q&A here one more time just to see if we had any more questions. Anthony, there was one question for you. I think you answered it in the chat already, Anthony, but maybe you could just go over it quickly for us again for those who maybe didn't see it. It was in regards to selling a hybrid for more than, if someone has been selling a hybrid for more than 1 year but haven't applied for PBR for either of the inbred parents, would a breeder still be qualified to apply PBR for the inbred if inbred parents have never been sold before in Canada? Boy, I'm glad you're here because this is technical.
That's a really technical question, okay? And here's our sort of thinking on it. In order for something to be qualify as a new variety, and that's a condition of protection, so it has to be new to get PBR protection. Our definition of new is you can sell for up to 1 year in Canada or 4 years in another UPOV member country for all crop kinds except for trees and grapevines, right? Then it's 6 years. So the specialty, we talked about longer duration of protection, 25 years for trees and grapevines, take longer to breed. Novelty period, 6 years in another UPOV member country. So our opinion, our legal view on can you start selling the hybrid first longer than 1 year and then protects the inbred parents later, for us the answer is no. And the answer is no for this reason. is you've already exploited the hybrid. You've already commercialized the hybrid. You're deriving benefits from the hybrid. You knew that the rules were 1 year in Canada, up to 4 years in UPOB member countries. So some people may have missed that. But I think the advice I would say is, you know about it now. So if you have other inbred lines you're seeking to protect, think about that. Think about that from first commercialization, and come talk to us, and we'll advise you on how to seek PBR protection.
Thank you so much, Anthony. Before we sign off here, Melanie, if you could just refresh our memory once more about your social media project that you mentioned before we end for the day. I'd just love to remind people about that and how they can help out.
Yeah, for sure. So we've curated a couple graphics that we're going to be sharing on Twitter, LinkedIn, and I believe Facebook. Twitter is probably the easiest one to hook into, or LinkedIn, seeds_Canada. And it just kind of is a catchy tagline, bringing attention to PBR compliance, basically. So look for it. I believe yesterday there was the first tweet out, so you can look for that on our channel, and retweet, share, etc. Yeah.
Perfect. Thank you so much, Melanie. And thank you very much, Todd and Anthony, for your time today. That was great, everyone. Hope you all have a great day. Thank you again to our webinar sponsors, 2020 Seed Labs and SeCan, for their support. Like I say, a recording of this webinar will be available in the coming hours on germination.ca. Thank you to our audience for spending your lunch hour with us. It was a pleasure to have you all here. Again, Anthony, Melanie, Todd, thank you so much for your time today. Have a great day, everyone. Take care.